Hi viewers, welcome to the session Policy, Legal Framework and Institutional Arrangements for Proposed EIA in India Part 1 of the course Environmental Impact Assessment for Environmental Health. We know till now that economic development in developing countries has focused on immediate economic gains, and as a result, environmental protection has not been prioritized. The reason for this is because economic losses from environmental degradation often realized only long after the economic benefits of development has been realized. The lack of environmental concerns in development and planning processes and detrimental impact of economic development activity has led to the advent of environmental impact assessment, popularly known as EIA processes. The basic purpose of these EIA processes is to provide information to the decision maker and the public about the environmental implication of proposed actions before any decisions are made. Now, we know that EIA process has become the most common institutional mechanism for integrating environmental consideration into national socio-economic planning. It is an analytical tool for assessing development programs which have an adverse effect on environmental or on human health. It has also become a crucial tool in guiding policy choices and has helped to create an environmental awareness amongst agencies involved in project implementation. The system of EIA has the capacity to minimize potential environmental damage or even prevent the occurrence of such problem at the preliminary stage of project formulation. The EIA reports cover the impact of development projects on ambient air and water quality, land degradation and ecology. For furthering transparency in the project appraisal process, significantly public hearing has been made mandatory for critically polluting activities. So, in recognition of the importance of public education, relevant project document and EIA reports are now made available to the public at designated places and through newspaper insert. Suggestions made by the publics are incorporated in the project design whenever possible. If we look at the provision made in the Constitution of India, we will find adequate provision for protection of environment and forest. For example, Article 47, it provides for protection and environment of health. Article 48A is directed toward protection and improvement of environment and protection of forest and wildlife. Article 51A says it is the duty of every citizen to protect and improve the natural environment. Following the United Nations Conference on Human Environment, which was held in 1972 in Stockholm, a constitutional amendments inserted relevant provision for environmental protection in Constitution in Part 4, Directive Principle and Part 4A, Fundamental Duties. In India, if you see, EIA evolved in the late 70s when the Planning Commission requested the then Department of Science and Technology and subsequently Department of Environment to examine river valley projects for their environmental impact. Thereafter, the Ministry of Finance, Department of Expenditure made it obligatory for the Public Investment Board to adequately deal with the environmental aspects and cost of such measures for all development activities. The Environmental Protection Act 1986 has made environmental impact assessment mandatory. The EIA was made mandatory requirement under Environment Protection Rule 1986 with the objectives: number 1, predict the environmental impact of project; number 2, find ways and means to reduce adverse impacts; number 3, shape the project to suit local environment; and 4, present the predictions and options to the decision makers. A significant notification after that by the Ministry of Environment and Forest in 1994 makes it statutory for an EIA study to be conducted for almost all developmental activities, small and large, which must be evaluated and assessed by an impact assessment agency, Ministry of Environment and Forest, which may consult an expert committee if deemed necessary. In India, the formal legal framework governing the EIA process was brought about in the form of EIAin notification in 1994, which was enacted under Environmental Protection Act 1986. The 1994 notification was amended several times in a span of 11 years before the EIA notification of 2006 replaced it. The salient provision of the notification were: environmental impact assessment was limited to 30 activities. Only the central government was empowered to appraise the projects. Two-stage clearance was provided for site-specific projects. Public hearing to be held only if required, and a time limit was fixed for making decisions on the proposal for environmental clearance. If we talk about EIA notification 1994, on 27th January 1994, the MOEF notified mandatory EIAs under Rule 5 of the Environmental Protection Rule 1986 for 29 designated projects. After amendments, now 30 activities. This is the principal piece of legislation governing environmental impact assessment. Following the notification, the ministry constituted 5 expert committees to cover industry, mining, river valley, thermal power and infrastructure. For example, port and harbors, highways, airports and miscellaneous projects. These committees consider cases from a technical angle, and in many cases, site visits are made for appreciation of ground realities. The recommendation of the expert committee are then processed by the Impact Assessment Division of Ministry, and final decisions are made regarding environment clearance. As per the notification, no development activity can be taken up unless the conditions stipulated under the respective environment and forestry clearance have been complied with. The Act was amended on 10th April 1997. In this amendment, the process of environmental public hearing was introduced in environmental clearance. The next amendment was on 30th June 2002. In this amendment, pipeline and highway projects are exempted from EIA, but conducting public hearing was mandatory. The investment cost considered are criteria for environmental clearance. New projects less than rupees 100 crore and expansion or modernization project less than rupees 50 crore were totally exempted from EIA. Next amendment was on 20th February 2003. In this amendment, location sensitivity was taken into consideration. Next amendment was on 7th May 2003. In this amendment, river valley projects including hydropower project, major irrigation projects and their combination including flood control project, except projects relating to improvement work including widening and strengthening of existing canal with land acquisition up to a maximum of 20 meters on both sides put together along the existing alignment provided, such as canals do not pass through ecological sensitive areas such as national park, sanctuaries, tiger reserve and reserve forest. Next amendment was on 4th August 2003. In this amendment, every project proposal to be located in a critically polluted area within a radius of 15 kilometers of the boundary of reserve forest, ecological sensitive areas, which include national parks, sanctuaries, biosphere reserve, and any state shall require environmental clearance from the central government. Amendment on 22nd September 2003. In this amendment, no public hearing was required for offshore exploration activities beyond 10 kilometers from the nearest habitated villages boundaries, gothans and ecologically sensitive areas such as mangroves within a minimum area of 100,000 square kilometer, corals, coral reefs, national parks, marine parks, sanctuaries, reserve forests and breeding and spawning ground of fish and other marine life. Amendment on 7th July 2004. In this amendment, EIA becomes mandatory for construction and industrial estates. Amendment on 4th July 2005. The amendment provides that projects related to expansion or modernization of nuclear power and related projects, river valley projects, ports, harbors and airports, thermal power plants and mining projects with a lease area of more than 5 hectares could be taken up without prior environmental clearance. Now coming to the EIA notification 2006. The EIA 2006 is an outcome of the report of the Govindarajan Committee and financial assistance from World Bank and suggestion for the review and revival of the existing EIA norms in India. In 2006 notification, it became mandatory for all new projects or activities on expansion or modernization of any existing project or activities and any changes proposed in the existing product mix in an existing manufacturing unit included in the schedule beyond the specific range to seek environmental clearance from the central government or state government as the case may be. According to this, the project will go to the state for clearance depending upon the size, their capacity, area instead of based on investment. As we have seen earlier, it was based on investment. Amendments on 22nd December 2014. In this amendment, exemption of industrial shed from requirement of environmental clearance under the provision of EIA notification 2006 was made. The matter has been further examined in the ministry and the clarification which was issued was that the word industrial shed implies building, whether RCC or otherwise, which is being used for housing plant and machinery of industrial unit and shall includes godowns and building connected with the production related and other associated activity of the unit in the same premise. The list of projects requiring environmental clearance from the central governments are number 1, nuclear power and related projects such as heavy metal plants, nuclear fuel complex, rare earth. Number 2, river valley projects which include hydropower, major irrigation and their combination including flood control, ports, harbors, airport except minor ports and harbor. Petroleum refineries including crude and product pipeline, chemical fertilizer whether it is nitrogenous, phosphate other than single superphosphate, then pesticides, petrochemical complex both olefinic and aromatic and petrochemical intermediates such as DMT, caprolactam, LAB etc. and production of basic plastic such as LLDP, HDPE, PP, PVC etc. Then next is bulk drug and pharmaceuticals, exploration for oil and gas and their production, transportation and storage, synthetic rubber, asbestos and asbestos products, hydrocyanin and its derivatives, preliminary metallurgical industries such as production of iron, steel, aluminium, copper, zinc, lead and ferrous alloy and electrical arc furnaces like mini steel plants. It also includes chloralkali industry, integrated paint complex including manufacture of resins and basic raw material required in the manufacturing of paints, viscose staple fiber and filament yarn, storage batteries integrated with manufacturers of oxides of lead and lead antimony alloy, all tourism projects between 200 meter to 500 meters of high water line and at location with an elevation of more than 1000 meter with investment of more than 5 crores. Thermal power plants, mining projects with lease more than 5 hectares, highway project including widening and strengthening of road with marginal land, acquisition along the existing alignment provided it does not pass through ecological sensitive areas such as national parks, sanctuaries, tiger reserve, reserve forest, etc. Tarred road in the Himalayan and forest areas, distilleries, raw skins and hides, pulp and paper and newsprint, dyes, cements, foundries, electroplating, meta and aminophenol. So these were the list of 60 industries which were included in EIA notification. As per the process laid down in the 2006 notification, industrial, mining, infrastructure and other development projects are categorized based on the size and scale of the projects. Projects such as coal mines above 150 hectares and thermal power plant TPP above 500 megawatt are category A projects and appraised at the central level. Smaller projects such as non-coal mining projects below 50 hectare and river valley projects below 50 megawatt are category B project and appraised at the state level. The category B projects go through a process of screening where the state level expert appraisal committee SEAC determines if a project requires an EIA report or not. Accordingly, projects which require an EIA are called category B1 projects and projects which do not require are called category B2 project. The project proponent are then required to prepare a draft EIA report based on the terms of references given to them by an expert appraisal committee EAC at the central and SEAC at the state level. This is followed by a public consultation in which the affected people are allowed to voice their opinion regarding the project. Thereafter, all documents are appraised by the EAC or SEAC. The EAC or SEAC, as the case may be, may then either reject the proposal or grant an environmental clearance EC to the project. On 23rd March 2020, the Ministry of Environment, Forest and Climate Change MoEFCC invited comments on a new draft EIA notification. The draft notification, which seeks to replace the earlier 2006 notification, was made open for public comment for 60 days. However, since the period for public comments coincided with the national lockdown in lieu of the COVID-19 pandemic, several environmental groups demanded for the comment period to be extended. Now, the MoEFC has extended the time for public comments. Once the public comments are received, the MoEFCC will take them into consideration before finalizing the draft notification. As per the recent amendments to the Environmental Protection Rule of 1986, made on 18th March 2020, the validity of all draft notification has been extended to 725 days, 12 instead of 545 days, thereby giving the MoEFCC 725 days to finalize the draft notification. So, to conclude the session, in this session we have learned that EIA in India is mandatory analytical tool for assessing development program which have an adverse effect on environmental or on human health. By responding to the need to integrate environmental and development decision making processes, EIA has contributed to the economically efficient, socially equitable and responsible environmental management. The tool has also been praised for its mandatory provision by the public for public input. A number of guidelines and bodies have been established by the MoEFCC to implement and enforce EIAs. If we see in India, the formal legal framework governing the EIC process was brought about in the form of an EIA notification in 1994, which was enacted under Environmental Protection Act 1986. The 1994 notification was amended several times in a span of 11 years before the EIAin notification of 2006 replaced it. 2006 notification has also undergone changes over the years. There have been exemptions from public consultation given to the certain category of the project, increase in the validity period of an EC, and even attempts are made to streamline and quicken the process of granting EC. Despite that, the 2006 notification has continued to be used by project affected people and non-governmental organizations in order to reduce the social and environmental cost of projects, and on 23rd March 2020, the Ministry of Environment, Forest and Climate Change invited comments on a new draft EIA notification, and the draft notification, it seeks to replace the earlier 2006 notification. Thank you.